actually on prisoners' rights, all the important judgments and the recent trends, which I'm sure many of you are aware of, but because my topic is recent trends in prisoners' rights, I've prepared it. And basically, I'd like to, can we please begin the meeting? As we all know that the main basis for our prisoners' rights is really the Articles 20 to 22 in our Constitution. Article 20, which gives three specific rights against self-incrimination, against the right to silence, the rule against double jeopardy, and the rule of no retrospective punishment. Apart from that, Article 21, which has been the bedrock of all our public interest and our right to life judgments, and Article 22. Can we? 22, which again gives you the right to legal aid and other rights. I'll go very briefly over those. What I'd like to really begin with is a reminder to ourselves that I'm sure most of you all know these judgments, but what I'd like to really begin with is a reminder to all of us that really PIL began with prisoners' rights, began with the fact that people were in jail and post-emergency, the miserable conditions. Can we have the next slide? Just keep moving.
Next.
It began with the Senara Khatun judgments where, because of the post-emergency, when people were in jail, political people were in jail, and they discovered the miserable conditions of people in jail and wrote letters to the Supreme Court of India, which were converted into PILs. And the whole edifice of work in prisons is actually comes from Senara Khatun's judgment, which is that legal aid is a right. The prisoners have their fundamental rights, and they have a right to live with dignity, and they should be given certain rights, and if they are there in jail for longer, then they should be released. And from your bail, not jail, that was the principle that was set out in Senara Khatun's case, and this is what has continued till recently. There are certain other cases where the right to bail has been emphasized, and bail has been, like Modiram's case, where it was said that personal bond should be given. Then in common cause judgments, where it was said that if a person is in jail for a period over 6 months, if the trial hasn't begun for more than a year, and the punishment is maximum 3 years, they should be released on bail. If they are in jail for, it's okay, the PPT is there.
No. See, these are very important, Monica. See, now, for example, more than half the period you should be released.
Yes.
We want to stress for our young lawyers. Some of them may not be aware of that. So this is a very important thing to say. No hurry, just very important. Just make it bigger. We'll make the print bigger so that they can see.
Full screen. If you do full screen, do F5. No, just do full screen.
Yeah, that's good. Can everybody see it? Right?
Yeah. Now, can we have the next slide on Senara?
And Monica,
yeah.
Once you want to stress, give a little bit of time for people.
Okay.
The ones you want to stress.
So, really, in Senara Khatun's case, what came out was the fact that people in jail are really not the powerful and the rich, but really the poor and the ones who, even if they have a bail order, they can't get out. So, the whole question of personal redress and bond was really what was emphasized in Senara Khatun's case, and the fact that people who thrones in the community that should be recognized and people should be released on bail. So, bail or jail was really the basis that was laid in Senara Khatun, and then after that we have seen subsequent judgments in which this has been emphasized. Can we have the next slide? The other thing that was also came out was legally the fact that poor people actually can't appoint a lawyer, so they're there for longer periods. And legally, then later on in Khathi's case became a principle where they said that if there is no lawyer present in the trial, then the trial itself will be initiated you have to be given legal aid. But also interesting is that there was a case some 2 years back, Raju versus State of UP, in which the person actually in the High Court didn't have a lawyer, and the question that was the point that was argued in the Supreme Court was that he didn't ask for a lawyer, and it was reiterated by the Supreme Court that it is not the duty of the accused to ask for a lawyer, it is the duty of the court to ensure that a lawyer is given to the accused. So the ball is very much in the court, court, and they are the ones who are supposed to ensure that legal aid is provided to the accused. So this has been the first round of judgments on legal aid. The second thing, of course, all of us know is that the next trend came about as right to against torture and right of people accused to against illegal detention. And there it culminated from, it began with Rudolph's case in 1983, where for the first time a person who was in jail for 14 years and not released, despite the fact that he should have been released, he was given compensation. And then in Neelavati Behra's case, the Supreme Court held that compensation, that illegal detention is a violation of your fundamental right to life, and custodial death also will lead to apart from other criminal case being filed and departmental inquiry being taken, it also leads to a particular remedy of compensation being given. Recently, there was a case in which Ranjana Desai gave 20 lakhs as compensation in 2013. Also, what is very interesting for me over here is the fact that it culminated in T.K. Basu's case, but there was also a struggle about encounters and whether encounters, apart from compensation, we were really keen that people should be prosecuted. And fake encounters, that there should be a prosecution for fake encounters. In Andhra Pradesh, there was a judgment in 1996. And then later in Bombay, we at Committee for the Protection of Democratic Rights and PUCL filed a PIL on the fact that, apart from compensation in fake encounter cases, you must have prosecution. And at that time, the Bombay High Court didn't give us the order. And now all the matters have come to the Supreme Court and they're pending the PIL for filing prosecution in fake encounter cases pending. But what is interesting is that the Supreme Court in Sohrabuddin's case and in Narmada's case has actually said that prosecution, CBI inquiry and prosecution. So prosecution is actually happening without in these cases. So there has been a kind of a build-up of these cases. The second thing is that, of course, the right of prisoners in Sunil Batra's case and conditions in jail. In Sunil Batra's case, what was important was they said that solitary confinement should not be is not permitted and it's violation of fundamental rights. The other thing, fettering and of prisoners is not permitted and it is a violation of fundamental rights. What it also said was that there should be. What it also said, the two Sunil Batra judgments also said that the district magistrate should visit the jail every week and talk to the prisoners and find out what their conditions are and give a report. And there should be a grievance box in every jail and every prisoner should have access to it, which should be on a lock and key, and the key should be with the district magistrate, and the complaint should go to the sessions court, the sessions judge, who will look into the complaints and take action. Of course, it said that no action can be taken against the prisoners for this except if it is found to be a false case. But this is something that actually in prisons we do find when we are working over it, there is a complaint box, but where is it kept and how accessible is it is really what we need to look at. So the Sunil Batra's case has actually given the basis for prison work and prison reform work. In Ramamurthy's case, actually the Supreme Court, just listed out what is wrong with the prisons, but unfortunately, the judgment is very, disappointing to not use a harsher word, because the terms are like when they talk about that the Bulla Committee report should be implemented. They say that the new prison act should come in. But the point is that what they say is that the directions are given in the They give their recommendations are to apply mind, to consider, to deliberate, to examine, to reflect, to ponder, to think about, to take needful steps, to ruminate. So, I mean, ultimately, if you're going to tell people just think about it, you're basically saying, I'm not telling you to do anything about it. So, that is the tragedy of the Ramamurthy judgment. In Sunil Mujan's case, it was held that parole and furlough, when you're out, that will be counted as a period undergone. And this has been reiterated in later judgments. So actually, what one finds is that post 1997 and the D.K. Basu judgments, there's only been a build-up of the principles which have been laid down by the Supreme Court. But as I said, in encounters now, because if there was no D.K. Basu, we would have had a judgment in encounters case saying that please file cases. What I found is that the recent judgments, one of the most progressive judgments is this in state of Maharashtra versus Said Shoaib case. This is the case of the accused who were in Bombay jail, in Area Road in Bombay. They were accused in the Aurangabad blast case, the Mumbai train blast case, as well as which is the third, Malegaon blast case. Now, the real story behind this is actually the accused where they wanted the typical modus operandi in Makoga cases and UMA cases, but in Makoga cases in Mumbai is to ensure that one of the accused becomes an approver. And this is the trend which started with the 1993 bomb blast case where you get an approval and then on the approver's evidence you get everybody convicted. So here they actually wanted the prisoners to be turned approvers, and the prisoners, so they were going to be selectively transferred. Two of the prisoners were the main accused, who were seen as the strong people, were actually going to be transferred to Nagpur jail. And they resisted the transfer because they knew that if they are transferred, the unity of that particular group of prisoners will be broken, and one of them, the weakest link, will be turned into an approver. And as we all know, Malegaon and Aurangabad, now we know that after Asimanand's confession that these are actually false cases. But this is how the state operates. So apparently they resisted and they were regional by the prison staff and they were transferred to Nagpur. The lawyer moved, in this case the court, the sessions court before whom the trial was pending, the special court had ordered the transfer, and the matter went to the High Court, and the allegations of torture and beating up were made. The High Court